Thank you very much. It's a great joy for me to be here with you today and to discuss a topic that I find fascinating. So I hope I spark a bit of that interest to you as well. I'm going to talk about the role that culture plays in international criminal proceedings. This is the topic of my PhD. And while the research is still ongoing, I'm going to present some of my preliminary findings. And I'm focusing mainly at the ICC, but some of these findings, I know that they're also very relevant for the domestic prosecution of international crimes as well, because the same type of challenges are also encountered there. Now, when I talk about culture, what do I mean by that? Because it's a very broad term. And at one point, anthropologists identified around 170 definitions of the word. So it can be, a system of traditions and beliefs expressed in an abstract form through which people just communicate with each other and talk about life. But what I do in my research is actually I take an emic approach. And in anthropology, this would mean that I look at the participants in the trials, how they themselves define the word culture for themselves, so their own culture, but also for the culture of the other. So I look at how the prosecution, the defense, the victims' representatives, judges, the defendants themselves, their own witnesses, how do they identify as something that is cultural? And what I see is that when facts are being established throughout these trials, what happens is that these notions, these concepts that we have about life, they are actually, they are being challenged on the assumptions that we have about their universal definition. So are there universal definition about certain words, or it becomes more challenging to find a sort of common ground? Now, how I do this very briefly, in this presentation, I'm going to talk specifically about 3 trials at the ICC, Lubanga, Katanga, and Ongwen. Lubanga and Katanga were from 2006, 2012 was Lubanga, Katanga 2007, 2014, and they were both from Congo. And Ongwen from Uganda was prosecuted between 2014 and 2021. So these are the trials I'm going to discuss today. And I'm conducting an in-depth analysis of the publicly available trial transcripts. I'm also looking at the decisions and main submissions of the parties. And I use this qualitative program NVivo, through which I map the themes that emerge in these trials, connected to the crimes that are being prosecuted. I also conduct literature review, and in the case of Dominic Ongwen, I was also able to observe the trial from the public gallery. So now what I notice when I'm analyzing these trials, that certain areas of contention sort of appear, and starting with the, well, I didn't put it here, but the linguistic one. So beyond the issue of translation, because the languages of the court are English and French, and of course you have Swahili or Acholi in these cases, and it needs to be translated in the language of the court. But besides finding the exact equivalent from one language to the other, it's also the matter of placing the word in a specific context. And I'm going to discuss about that later. And then there is also the issue of where and when the crime was committed. So how people refer to distance in kilometers, or they refer in time, how much walking time took to reach from A to B. In terms of time, there are also, you have to find the match between the expectations of having a very precise timeline according to a Gregorian calendar with exact dates, or people who refer to something that happened during a certain season, or maybe in relation to other events. So a sort of an approach to chronology in terms of main events that happened, and around that cluster, then you remember other significant things that happened. When you have the crime of child soldiering, for example, you will have submissions about childhood and what is a child and how do you establish age. The crime of forced marriage, submissions about what is forced marriage, does it differ from arranged marriage? If ceremonies are not being performed, is this a marriage? What is marriage in a specific local context? And the issue of spirituality, this was mainly addressed in relationship to the criminal responsibility of the accused. And of course, this is not an exhaustive list. So these are just to give you an idea of the type of themes that I'm identifying in my research. So for the purposes of the talk that I'm giving today, I'm going to look at two specific issues that were addressed in all these trials. One of it is child soldiering. Katanga and Ongwen were found guilty for child soldiering. Katanga was acquitted. And then the second issue would be spirituality. In Lubanga, it played a bit of a minimal role. It was more mentioned in reparations, but in Katanga and in Ongwen, it played more of a prominent role. And what I've done is that basically why I look at completed trials at the ICC is because I want to see how these concepts circulate throughout the trial. So I want to see how are they introduced, by which parties, for what purpose, and how the judges evaluate them, and if they still make it, for example, in appeals, reparations, or in other phases of the trial. So when it comes to child soldiering, according to the Rome Statute, the issues are quite straightforward. You need to have the children that are enlisted, conscripted, or used in hostilities need to be under the age of 15. So then when it comes to these trials, two main questions that were asked in both of them is, were there children in these armed forces where the defendants held a position of leadership? And were these children under the age of 15? Now, this is not an issue that is specific to the ICC. There was, similar cases at the Special Court of Sierra Leone, and there the defense argued that actually the ending of childhood in traditional African settings has little to do with achieving a particular age and more to do with physical capacity to perform acts reserved to adults. And this theme actually is something that was taken by, or it occurred also at the International Criminal Court. The Lubanga trial in the judgment actually made a lot of reference in the findings of the Sierra Leone. So it would have been interesting if the judges would have accepted this defense. They didn't, but I'm just saying that although the ICC is not bound to rely on these decisions, they made use of a lot of the findings of the Special Court of Sierra Leone. And tying to this quote, then going into the trials at the ICC, in the Lubanga trial, right from the outset, the judge actually drew the attention of the prosecutor to the fact that the questions that he was asking of the witnesses were not precise enough. And he said, children means different things to different people, and that there is this particular requirement, that the children need to be under the age of 15. And currently, how the dialogue went, it was a bit too ambiguous. So then when witnesses were indeed asked very precise questions about the meaning of the word child, one witness, for example, said, children were people of the ages of 15, 25, 35 years old. Another witness in Katanga trial said the people that I call children were over the age of 20. And in Ongwen, children is a cultural term used in Acholi because if I'm older than someone, whoever is younger than me is a child. And these are only 3 examples, but the transcripts abound of this kind of examples where if, without having a clear clarification of what witnesses say when they mention that they saw children within the armed forces, this doesn't necessarily imply that they were minors or they were under the age of 15. Another dimension of how the word, so I talked about translating the word from one language to the other, and then it's how this word can be used in a context, is that in the context of certain armed groups, the word children was used to denote an inferior, a person of an inferior rank. So you would have the leader who would be the father figure, and then the subordinates or the foot soldiers would be called children. Where this became particularly significant was when the prosecution submitted into evidence a logbook of the UPC, the armed forces that Lubanga was a leader of, in which the word children was mentioned several times, and in relationship to we need to recruit more children for the army. So the prosecution submitted this as evidence of the fact that Lubanga was active and they were active in recruiting, enlisting child soldiers and using them in hostilities. The defense brought witnesses who explains that actually in this context, not having means for obtaining children meant that they couldn't get more recruits for the army, and this was the actual meaning of the word. And in Katanga as well, some witnesses said that militia and children were used interchangeably. Also, when children were disobeying, their parents would refer to them as militia. And again, connected to this hierarchical dimension or the relationships between people, Thomas Lubanga was also called Papa Lubanga by several witnesses and also by parties participating in the trial, thus reinforcing this idea that children and parental relationships can have different meanings, or that words can, depending on the context, can have a different significance. And what happened in the judgment is that in relationship to this particular logbook, actually the judges considered that because there was no reliable guide as to the meaning attributed to the word children, the chamber declines to rely on the document as support for the contention that there were children under the ages of 15 in the ranks of UPC. So this is very interesting because the defense managed to seed enough doubt in the prosecution story as to have a piece of evidence such as this one not relied on, which was an internal UPC document. And then there is also the concept of kadogo, and this was not translated because when I said that there are different languages at the court, this was a concept that was not translated into English and French. And the reason why the parties relied on testimonial evidence on children, what is children, and this concept kadogo, which in literature is broadly used as loosely translated as child soldiers or male child soldiers. Why they had to rely on this kind of concepts is because the administrative evidence and the forensic evidence was either lacking or was very weak. So there was a lack of birth certificates, there was a lack of documentation, school records were very unreliable, and the forensic evidence that was brought forward was also not conclusive enough to pinpoint to the age of the children. So then in the absence, absent not having this type of evidence, then they had to rely on witness testimonies and to what these witnesses said about the presence of children in the armed forces. So the concept of kadogo was also highly contested, especially in Katanga and Lubanga. The defense in Lubanga said that the prosecution is basically, to a certain extent, misunderstanding the concept, which is a very broad age group, more or less between the ages of 13 to 17. And also they pointed to the fact that in certain circumstances, there were kadogi that were 18 or even older. So they basically claimed that the way in which this concept was used in this context was a relational one. Who am I in relationship to you? If the person is younger, then this person could be considered the kadogo, and not, as the prosecution was trying to say, that it belongs to a specific age group of very young children. The same in Katanga, they also relied on Swahili, and they said that in this language, basically the word kadogo translated per se would mean small or tiny, and that it can mean height, it can mean rank, it could also mean age, but it's not something conclusive. And in Ongwen, also witnesses said that they knew more or less that someone was a kadogo based on their size. So if someone was of the same size as themselves, they would call them a kadogo. Now, what happened in the judgments, as I said that in Lubanga and in Katanga, these were more contested, there is a bit more room for ambiguity also in the findings. So the judges said that yes, kadogo was sometimes, it meant children between the ages of 13, but sometimes it also refers to children over the age of 15. And then also here, children referred locally to kadogos in some cases were estimated to be under the age of 15 years old. So they relied on this concept to a certain extent, but they also put a lot of caution into that. And in Lubanga, actually, during the appeals chamber rejected the fact that the trial chamber in Lubanga had relied on the testimony of one witness concerning kadogi, saying that it has not been established that this term really specifically means under the age of 15, so they should not have relied on this concept in this particular instance. Where the Katanga and Lubanga differ from Ongwen is that in Ongwen, the fact that child soldiers were in the LRA was not contested. Dominic Ongwen was a child soldier himself. He was abducted at the age of 9. He went through this process as a victim. Therefore, what you see is that the concepts around childhood and kadogi, although they were mentioned, they didn't go so far in various directions as in the other two trials. And here you say that the language used by the judges is also a bit more specific. They said they concluded that this term, kadogo, was used in the organization to refer to soldiers of a young age. And then they list mainly the evidence that places this kadogo group downward of the age of 15 or 16 and between 13 and 15, and also that Dominic Ongwen used the word kadogi to refer to children. So somehow the definition of kadogi in the Ongwen judgment becomes more in line with the Rome Statute and with the legal requirements. And the other issue I'm going to talk about, so I'm not going to touch too much on Lubanga because it was only mentioned in reparations, but the issue of spirituality was used in Katanga and Ongwen in relationship to the criminal responsibility of the accused. So in Katanga, what the defense basically stated was that there were these fetish priests that were annexed to the army, but they were actually essential to the culture. They had real power, and that these fetish priests actually had a lot of power. They were more powerful, the most powerful after God. The prosecution took a different approach. They said that yes, there were these fetish priests. However, they played a minimal role. They were merely serving as to give some blessings before the soldiers went into battle, but they had no function in directing the commanders or the attacks. What happened in the judgment is actually the judges admonished the prosecution for not bringing more cultural evidence, more information on the fetish priests. They considered that this information would have helped them have a more informed and more nuanced opinion. And because of that, they felt that they had to take a more active role, cross-examine the witnesses themselves on these issues, and also direct the parties in their closing statements. They actually concluded that the fetish priests were in fact very much involved in the armed groups, that they played a pivotal role to the commanders, and that the involvement of the fetish priests really affected the course of the battle. However, they also stated that around the time when the Bogoro attack took place, when the commission of the crime, that the beliefs in these fetish priests diminished. Therefore, Katanga cannot claim that the responsibility was not his, or that the fetish priests were actually more influential than him. In Dominic Ongwen, it was, well, I'm simplifying because it was not extremely similar, but the defense also argued that the conflict in northern Uganda was steeped in metaphysics and spiritualism, and that the overall leader of the LRA, Joseph Kony, and Dominic Ongwen was the commander, but Joseph Kony is the overall leader, that he is an omnipotent leader, and that this army actually doesn't belong to him, but the spirits that talk through him. And therefore, they put forward two affirmative defenses of duress and mental incapacity. So Dominic Ongwen being kidnapped at a very early age, he was indoctrinated in this cult-like army and grew up into it. How the judges assessed the involvement of spirituality in the issue of mental incapacity, and again, I'm simplifying because we don't have much time. They recognized that Joseph Kony acted as a spiritual leader. This was an uncontested fact. However, they considered that when it comes to spiritual possession, all mental incapacity, and these two during the trial were almost conflated at one point, that irrespective of whether there could have been mental illness or as spiritual possession or not, this is immaterial because they didn't find that the evidence proved that he suffered to such an extent for his mental incapacity to be destroyed. So this also has to do with the very high threshold at the Rome Statute, because and if spiritual possession can be considered mental disorder is a completely different story, but the judges didn't really look into that. They just assessed that it doesn't raise to the threshold of mental incapacity. And when it comes to duress, they actually took a very similar approach as in Katanga. They noted the fact, so here I'm going to, these are my own words and I'm simplifying it a lot, but basically they split the witnesses into believers and non-believers or formal believers. And they said some witnesses believed indeed in the powers, in the supernatural powers of Joseph Kony, and felt that they have to obey him no matter what. However, these are the witnesses who claim otherwise, and they listed around 7 witnesses and their testimonies, where and from this they inferred the pattern that the longer someone stayed in the LRA, the less this person believed in the spirits of Kony. And also they drew a direct correlation between the behavior of Dominic Ongwen and his own personal spiritual beliefs. So although Ongwen himself didn't testify during the trial about what he believed, he only made a statement at the end. They inferred that because at times he disobeyed Joseph Kony, he must not have believed in his spiritual powers, which is a very interesting correlation. I think it has also to do with the fact that this kind of discussions take place in a court of law, where direct correlations or inferences need to be made between the evidence, the information presented, and the responsibility of the accused. And now to sum it all up, I would say that where culture becomes very relevant in constructing evidence has to do with its very elastic boundaries. So when you have mainly adversarial procedures, there is great benefit of incorporating culture, of putting the crimes in a context, in understanding the gravity of the crime. What did it mean for a certain community? What happened? So these are elements like the type of marriage, the stigma, all the things that happen around it. These are very relevant in constructing the case. Where it becomes dangerous is that it also can shed or can create enough ambiguity so that certain pieces of evidence are in the end not relied on. And that culture is, in many cases, can be seen as something peripheral to the case until it is not, until it is put into focus. And then I think it's important to have this kind of tools that, let's say, we do in anthropology, where these assumptions about the universality of things, these are challenged more often, and there is this practice of dealing with these things. Yes, because I think that in certain contexts, culture can also be misused and kind of cover up for some things. So would it be like, for example, Nancy Combs also wrote in her book that at one point there were some ambiguities in witness statements, and then it was revealed the fact that in their local culture in Rwanda, witnesses would not come forward immediately with information, and then they would reveal it later. And what happened, she said that at one point a lot of ambiguities or inconsistencies became explained away by the culture. So the response was like, that's why this is inconsistent, because it must have to do with the local culture. Maybe it does, but maybe it doesn't. So this is where the culture can serve as an umbrella to cover up for something that is not there. And in terms of the challenges that the ICC in particular is faced, I think that based on its potentially universal jurisdiction, with each situation that it opens a new geographic area, it will be confronted again and again with situations where not only that the participants in the trial will be very diverse. And here I'm not talking only the people that are coming to testify before the court, but there is also within the court different legal, cultural backgrounds that also interact. The prosecution with the defense, with the judges, they all have their own understanding. And you also have it, you see it in the dissenting opinions, for example, that in the judgment, one judge relied on Kadogo and the other one in appeals considered that this was not actually something that should have been done, that it shouldn't have been gone further with it. And I also think that similar challenges are also faced in domestic prosecutions. And yes, and this is why having a certain awareness and knowledge, and also knowing the risks that culture and the potential that culture can bring in to international criminal proceedings is essential. Thank you very much for your time.